I hope you're enjoying this Green Criminology Twitter conference, and I'd like to take this opportunity to talk a little bit about green criminology and the right to a healthy environment. Green criminologists have identified that environmental harms are poorly addressed through criminal laws and enforcement approaches that are based primarily on a criminal law enforcement approach of detection, apprehension and punishment. An issue for green criminology is that the assessment of harm rather than crime requires consideration of how the environment and individuals' rights might be impacted beyond the narrow confines of what is classed as a crime as defined by the criminal law, and then assess the standard criminal justice policy and practice. In this talk, one of the things I'm going to examine is the application of human rights norms to green harms, noting that the dictates of human rights law sometimes require states to act positively to uphold a citizen's rights, even where doing so may inhibit the effective operation of criminal justice. One of the issues that I'm looking at here is the idea that our justice systems need to consider issues wider than just justice through the criminal law, and also needs to consider issues around the way in which the rights of citizens, including a right to live in a healthy environment, might be something that can be examined through the use of human rights. So, starting point for this is a notion that criminal justice and human rights are often said to be in conflict. The extent to which human rights has a negative impact or restricts policing functions and criminal justice functions is something that is sometimes raised, given that, generally speaking, rights can only be interfered with for certain purposes. These usually include the fact that it's necessary to interfere with or temporarily suspend somebody's rights, that any interference is carried out in accordance with the law, and that any interference with an individual's rights or the rights of a group has to be proportionate. It should be the minimum interference necessary in order to carry out a particular aim, like protection of the public, protection of morals, crime prevention or national security. But one of the questions I'm raising in this talk is whether or not human rights can actually aid environmental protection and assist with people's environmental rights. This raises a question of whether or not there's a fundamental right to a healthy environment or to live in a healthy environment, and where that right might be found. And also considers some questions around whether or not the breach of environmental rights, whether perceived or actual, should be dealt with as a crime or should be dealt with in another one. So, while many criminologists will be familiar with ideas around the way that the criminal law constructs offences and the way that citizens have certain rights contained within some general legal systems, rights relating to the environment are actually spread across a range of human rights instruments. These include the Universal Declaration on Human Rights, which has different issues around environmental rights contained in Articles 22, 25 and 27. The International Covenant on Economic, Social and Cultural Rights, which includes some provisions on ecologically sustainable development. The UN Convention on the Rights of a Child, which talks about the right of children to live in a healthy environment that's suitable for their well-being and their development. There has been various case law and national legislation that's looked at how human rights principles can be applied to the question of whether or not we have a right to live in a healthy environment. And although not specifically enshrined in aspects of criminal law, rights relating to the environment are spread across a range of these instruments and allow for action to be taken when somebody's rights have been infringed. Okay, so going back to the UN Declaration on the Environment in 1972, I pulled out a couple of principles here to kind of illustrate the point I'm talking about. Principle 1 says that man has the fundamental right to freedom, equality and adequate conditions of life in an environment of equality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future generations. Part of what this does is talk about the right to live in adequate conditions and healthy conditions, and this principle that our environment should be one that allows us to live a life of dignity and well-being, and that the environment itself arguably shouldn't actually cause us harm. Principle 2 of this declaration talks about the idea that natural resources of the earth should be safeguarded for future generations and present generations, and there should be ideas of careful management of the environment. In part, what this does is it sets up the idea that our air, water, land, flora and fauna should be properly managed, should be managed in a sustainable way, and should also be of a quality that is adequate for present populations and future populations. So there's a kind of obligation to safeguard this. Some of these ideas are expanded upon in the United Nations World Charter for Nature, the 1982 Charter, which talks about nature being respected, its essential processes being unimpaired. It talks about ideas around our utilisation of land and marine resources being sustainable, not endangering the integrity or survival of other species, but also talks about population levels of wild and domesticated species being sufficient and sustainable. We shouldn't drive species to extinction. We shouldn't destroy the environment in such a way that it means that wildlife is unable to live in it, and that habitats should also be protected, particularly in respect of rare and endangered species, and that we should apply conservation principles that mean that we conserve the natural environment, we protect the natural environment, and ideally we improve the natural environment. There's also provision here that talks about nature being secured against degradation arising from warfare or other hostile activities. So you can see in these principles that part of what we're talking about is the idea that we should try and maintain a healthy environment, and we should try and limit human impact on the environment. So going back to some of our principles in the Universal Declaration on Human Rights, there are varied principles here. We talk about the right to social security, people having the right to realisation of the economic, social and cultural rights that allow for development of personality, a life of dignity. And we see here in Principle 25, everyone has a right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing and medical care and necessary social services. Well, in one sense, it's difficult to have a healthy life and a healthy standard of living if you're living in an environment that's dangerous or that causes problems. And so a potential conception or ideas to think about here are around the idea that the environment itself must be healthy and adequate for your health or standard of living. So although within the Universal Declaration it doesn't specifically or directly in one sense talk about the environment and the health of the environment, this is alluded to within the principles, and it's clarified in the way that this works in practice. And the Office of the UN Commissioner for Human Rights in 2015 observed, this is a quote, some issues around damage to the environment and environmental rights. And as it illustrates here, it says if you deliberately dump toxic waste in someone's community, disproportionately exploit their natural resources without adequate consultation and compensation, clearly you are abusing their rights. Changes in the environment can have a significant impact on our ability to enjoy human rights. In no other area is it so clear that the actions of nations, communities, businesses and individuals can so dramatically affect the rights of others. Damaging the environment damages the rights of people near and far to a secure and healthy life. So although that does not necessarily explicitly say you must have the right to live in a healthy environment, it indicates how this can be interpreted and how this is an important area. And in part in this discussion, what I'm thinking about is the fact that whilst there are sometimes conflicts between our justice systems, our human rights, there are conceptions that environmental crime and environmental harm impacts negatively on environmental rights, and so too does disproportionate exploitation of natural resources. And as we move deeper into looking at the specifics of what what human rights conventions and human rights law says in terms of the right to a healthy environment, part of what I'm arguing here is this is an area where there is some help for Greek criminologists in turning to human rights law as a way of examining and protecting the environment, and using human rights law as a tool that can sometimes be used to identify where the state has failed in its obligations to provide for a healthy environment. So within the European Convention on Human Rights, whilst there's no specific right to a healthy environment written within the Convention, several individual rights engage with this area, including the right to life, the right to respect for family life, Protocol 1, Article 1 on the right to peaceful enjoyment of possessions and property, and even Article 6, the right to a fair hearing, which is perhaps traditionally thought of in the context of the right to a fair trial and notions of being innocent until proven guilty, but can be applied to issues around environmental protection and environmental harm in certain circumstances. So, the right to life. And Article 2, the right to life, imposes some obligations on states to essentially protect the right to life and ensure that citizens are not caused undue harm. It has been applied in relation to a couple of cases that have examined the state failure to ensure the safety of the environment and to protect the environment, or a failure to act in relation to an environment that might be considered to be dangerous. So here is a Turkish case, which was the first European Court of Human Rights case involving loss of life in the context of a healthy environment, as far as I can tell. So in 1993, there was a methane explosion that killed 9 members of the applicant's family. There had been an expert report in 1991 which noted the possibility of explosion of methane gas from a tip near which the individuals concerned lived, but no measures have been taken to prevent this. Arguably, the state, being aware that there was a potential risk to life, should have taken action, and a complaint was raised under Article 2 of the European Convention, essentially to the effect that the accident has occurred as a result of negligence on the part of the relevant authorities. And this complaint was upheld by the European Court, which concluded there had been a violation of the right to protection of life in Article 2. In one sense, what this is arguing is that the state, aware that there was a possibility of something that would impact on individuals' right to life, and aware that the environment itself was problematic because of the risk of a methane explosion, failed to take action, with the consequence that individuals died as a consequence, in one sense, of living in an unsafe environment. A similar argument was raised in a Russian case in 2008, where the Russian government's alleged failure to take action in an area that was known to be prone to mudslides was raised in a consequence when 8 deaths were caused. So again, we're talking about a potentially dangerous environment, and one of the issues is where individuals have lived in an environment that was that threatens their Article 2 right to life, the state's failure to take action is deemed problematic. Here we're talking about an area that's vulnerable to mudslides and expose the residents living in the area to mortal risk. And what the court essentially said was that the failure of the authorities to implement appropriate land planning and emergency relief policies that would have engaged with the safety of the environment was problematic. Here we can also extend our consideration of environmental rights to issues around statutory nuisance. And in the UK, we have the Environmental Protection Act 1990, which defines nuisance as activities which are or are likely to be considered to be a nuisance or prejudicial to health. And this is defined within the legislation as the unacceptable interference with the personal comfort or amenity of neighbours or the nearby community. So the idea that you cannot enjoy the environment in which you're living in, the idea that there may be harms caused to you through nuisance. And the Act here goes on to clarify and classify some aspects of nuisance. Premises that are kept in poor condition, smoke that's emitted from premises, and smoke can obviously be harmful in relation to air quality and and cause health concerns. So can fumes or gas emitted from premises, dust, steam, smell coming from industrial, trade or business premises, accumulations or deposits of waste, and so on. And noise as well. Noise nuisance can be detrimental. And you can see how some of these issues all perhaps can combine to provide for an environment that perhaps isn't healthy and infringes on people's environmental rights. Even though these might not necessarily be dealt with as crimes, they might be dealt with as administrative compliance issues. But again, going back to our Human Rights Convention and the consideration of these issues in a human rights context, the right to enjoy your private life can arguably be construed as also a right to enjoy a healthy environment in the context of where there's interference with your enjoyment of your home and your garden. And there are two cases that illustrate this that I've identified here: Lopez Ostra v Spain and Guerrera v Italy. And these deal with industrial pollution and toxic emissions. So they're pollutions cases. And in the Lopez Ostra case, the failure to control industrial pollution was considered to be a violation of Article 8 of the European Convention because it had a serious interference with the applicant's enjoyment of their home. Similar issue in the Guerrera v Italy case, where the state's failure to deal with severe environmental pollution and toxic emissions also prevented individuals from enjoying their homes in a way that was considered to affect their private and family life adversely. So although this is around Article 8, part of it relates to the problems in the environment that impact negatively on people's right and ability to enjoy their homes. Within these cases, it identifies the issue of balance, a balance between the competing interests of an individual and the community as a whole, and the economic interests of the state, which can also be regarded as the interests of the community of the home. Now, in some instances, we might consider that the interests of the community might override the interests of the of the individual. So you perhaps have a balance between the rights of an individual to enjoy their property and their immediate environment and necessary commercial activity. However, in these cases, one of the things which was discussed was issues where a polluting activity violates national law, and where that is the case, where the state might be trying to argue, well, the economic interest outweighs the individual's rights to enjoy their environment in their home, becomes difficult to sustain. Because one of the things that the state has here is a duty to take positive measures to secure the enjoyment of an individual's right to life and their property, and failure to enforce existing law, particularly where there might be law that classifies that certain things are harmful in an environmental context, can engage Article 8. So here we have an issue where, in addition to the right to life points I've already raised, there may be some issues around enjoying your private life in a healthy environment, as I've identified earlier. This talk is kind of provided for by international human rights instruments. A further interesting twist on this comes up in relation to Article 6, in a case where the refusal of domestic authorities to comply with and their delay in implementing decisions of the courts, binding decisions of the courts, was considered to be problematic. This related to complaints that were raised about the effect of a tourist development on an important wildlife refuge that was adjacent to property owned by one of the applicants. And the court said that there had been a violation of Article 6 because essentially a judgment was, judgments were raised following two sets of proceedings, which basically required there to be some form of enforcement action, but this simply wasn't carried out. And so that in one sense rendered the judgments meaningless. This has been identified in other cases where, for example, here we have a case where a failure by the Turkish national authorities to implement a court order closing down 3 thermal power plants which were polluting the environment, meant that the kind of fair hearing provisions had been breached, because it kind of rendered the decisions effectively meaningless. I'll say just a little bit about the Aarhus Convention and how this also provides for environmental rights. It's based on 3 core pillars: the right to know about things that might impact on the environment, the right to participate in environmental decision making, the right of access to environmental justice. And what this does is it provides for the public to be informed of activity or specific projects that could adversely affect the environment, and crucially says that there should be some form of redress. There should be some opportunity to kind of obtain and secure justice. What this does is it gives members of the public and NGOs the right to challenge the legality of certain environmental decisions. It also requires that there should be a remedy mechanism, which could include injunctions that prevent environmentally harmful development or activities from going ahead in some circumstances. And within the convention, arguably, it recognises everybody's right to a healthy environment, as well as the opportunity to take action in order to protect that, and in order to allow for there to be scrutiny of decisions that allow things that take place that will harm the environment and will harm people's right to live in a healthy environment. So, although that is quite a quick examination of some of the ideas, part of what I'm trying to get across here is the idea that in our context of green criminology and using mechanisms to address environmental protection issues, we potentially have human rights conventions and national human rights law as additional weapons that can be deployed as part of our environmental protection toolkit. And the right to a healthy environment is potentially recognised in several different ways. It can derive from other rights, which I've talked about in this talk: rights to life, rights to health, rights to respect for private and family life, which are enshrined in human rights mechanisms such as the European Convention on Human Rights, but can be applied to the specific settings where the problems with the health of the environment actually impact negatively on individuals' other rights. In some jurisdictions and in some areas, the specific right to a healthy environment is written into either environmental or constitutional laws, so it's tangible and explicit within the legislation. And also it exists as what we might refer to as procedural environmental rights. So the example of the Aarhus Convention, rights that allow us to use procedural mechanisms in order to know something about threats that might harm the environment, development that might harm the environment, things that might lessen the quality of our environment and harm our environmental rights, and then to pursue remedies in order to require that those rights are upheld, that they are protected, and where they have been interfered with, to try and seek redress. So, in this area of a potential conflict between human rights and criminal justice, there are some areas where I feel we have human rights tools that we might be able to explore and might be able to use, as some of the case law that I've talked about here identifies, and that illustrates the manner in which we can use some of these additional tools within our environmental protection toolkit. Thanks very much, and enjoy the rest of the conference.